speaker is Lynette Olaginger. She's an attorney in private practice in Providence, Rhode Island, with a litigation practice concentrating in civil rights and employment and discrimination law. And cheating should be provided. Lynette served as the trial and appellate counsel for the plaintiff class in the landmark Title IX sex discrimination case challenging the treatment of women at Brown University. She is also a longtime cooperating attorney for the ACLU of Rhode Island, which has twice honored her with the Civil Libertarian of the Year Award. Lynette has litigated many high-profile civil rights cases in Rhode Island, including cases involving reproductive rights and First Amendment rights. Working primarily with the ACLU of Rhode Island and Planned Parenthood, Lynette has successfully challenged as unconstitutional many of the laws passed by the General Assembly in the 80s and the 90s, restricting decisions on reproductive choice, and has more recently testified before the General Assembly in support of passage of reproductive health care. Please welcome Lynette Olaginger.
So I've been told to talk into the mic. Can everyone hear me?
Yes.
Good. All right. I'm going to be brief because I can't follow our keynote speaker with justice. She was fabulous. And I think that the thing that worries me in part, maybe, I don't know what's the most, I get worried about all of this stuff, but I think about the last time that women or family members of women of childbearing age really had no legal access to abortion. You needed to be about 15 years old in 1973. So if you were born in the States and you were born after 1958, which is a long time ago, except for me, you just don't. You're not living these horrible questions, the horrible decisions, even if it wasn't you, even if it was one of your friends or just generically, what are my choices going to be if I am intimate with someone and I get pregnant? How am I going to move forward? Who am I going to talk to? What are my options? When Roe was announced, that transformed the legal landscape. It decriminalized pretty rapidly a lot of decision making by women. And, and so there is a whole loss of institutional memory. And whereas our keynote speaker from Ireland was talking about events that happened in 2012, these are current events. People are living these issues. And I really think that in some respects it's more important to get folks up here who can talk like Edie did about our history and the history that's going on in other countries, and that we don't want to be put in the posture where our doctors and the women that they're treating are facing being criminals. Or if you have a loved one or a friend who decides to give you a ride to another state, that they are engaging in a felony. These are things that are really on the horizon. And, Roe was announced in 1973, and almost immediately after its announcement, various legislatures got right back to work trying to whittle away at it. And for the first many years, the cases that were coming up across the country were ones that basically were pushing back against inroads on Roe. Because what Roe did was essentially said that all of these laws that criminalized and prohibited abortion at all were unconstitutional because they intruded on a woman's right of privacy to make those fundamental decisions about whether or when or not to bear children. And what Roe said, and I don't want to get into all of the weeds of it, but basically that although the state had an interest in regulating the provision of pregnancy termination, that during the first trimester, more or less, it was between the woman and her doctor, and then starting around the second trimester, it was laws that dealt with protecting maternal health could kick in, and that at the point of viability, the state had an interest, if it chose to, seek to enforce it in preserving potential life, but could not pass laws that interfered with the life or health of the pregnant woman. And shortly after that, we had laws that then required informed consent and required waiting periods and required more than one visit, and that the person who could tell you about things was the doctor who was going to perform the abortion, and that your spouse, even if their spouse was abusive, had to be informed, might even have to give consent or at least knowledge, and so on. And all of these laws were litigated, and over time, the original ones were struck down, they were pushed back, but over time, they chipped away at Roe. And then in 1992, we had Casey, which at that point there was a very strong concern that it was going to undo Roe. But there was, I think it was 5-4, and but they came up with a new standard. They said Roe still exists, but there was a new standard of undue burden. And then there's a whole other round of litigation which has been going on for the next 20, 25 years that has, again, not just chipped away, but taken off large chunks. So that the standard is now an undue burden, whether the restriction creates obstacles for a large fraction, whatever that means, and that's where all the litigation is, a large fraction of the individuals affected by it. And so one of the effects of that is that in those states where they pass those laws, that instead of looking at the law and saying, well, that doesn't conform with Roe, you now have to have a whole round of litigation about what the actual impact is. And so we see clinics closing across the country because they can't afford to stay open with all of the additional expenses and regulations. To the point where in 2016, we finally had a good decision from the Supreme Court in Hellerstedt, which again looked at all of the individualized decisions and said that was too far. But that too was 5-4, and I'm sorry, it was 5-3 because Justice Scalia had passed. But one of those 5 was Justice Kennedy. And that's where we are now. So, you know, I don't think that it is an undue alarm to say that we're on the cusp of perhaps having no more protection at all. And that could look 2 ways, at least. One is that there's no protection and the states are free to do what they want. The other one, which was also part of the original Roe litigation, was an argument that a fetus is a person within the meaning of the 14th Amendment. Now, the court in Roe rejected that, but we have a different makeup of the court now. And we've seen constitutional amendments in various states and statutes that are designed to declare. There was one in Rhode Island right after Roe was announced that human life begins at conception, and therefore from the moment of conception that embryo or fetus has the same rights as a person within the meaning of the 14th Amendment. So now you're having an equivalence for the woman, the pregnant person, and the fetus. And then the question is, well, what does that mean? One of the arguments that was mentioned in Roe was, are we going to start counting them as part of the census? Are they part of the population? You can look at it a different way. I know I'm worried. I'm very worried about what the landscape is going to be. It may be that we can't energize, I guess I'm now using Trump terms, we can't energize our base until we're back in the situation that families and women were in Ireland. I hope that's not the case. But, because I'm going to tribute, you know, the age and make up to the Patriots game, and the Patriots were winning the last time I looked. But we need to get the message through to the people who are of childbearing age in particular, and their families, and their loved ones, that, you know, it's all on the line right now. We need to convince our legislators that they will be voted out if they don't respond to the great will of the majority. So far, they don't seem to think that there's any political cost. So that's not the legal landscape, that's the political landscape. There's only so much I can do as a lawyer. I can go and argue all those cases, but if the Supreme Court decides that there is no constitutional right of privacy that includes, as a fundamental right, the decision whether or not to bear children, then that part of our arsenal is gone. So on that happy note, enjoy your week.